Good morning, everyone. Welcome to the WILMIC Summer Seminar. This is our, I believe, 5th consecutive summer of putting on the summer seminar. We're going to talk about estate planning today, but the first half of the program, I'll introduce Claude in a second. Claude will be dealing with lots of malpractice issues and things that he's seen over his many decades of work. And so we'll have that for you. And then the second half of the program will be a hopefully interactive panel discussion where we encourage all of you to get involved in the discussion with our fine panelists and get a discussion going about the myriad of estate planning issues that you all face out there. I want to welcome those of you on the web and let you know that on your screen you will notice 2 links below the video screen. One is the link for the written materials, which you should already have, but if you don't, you will be able to access those through the link. And then the second link is a link where you can submit questions. And that will pull up your email browser, your email client, and you can send a question or comment to us. We will get it in real time, and we will pass it on to the speakers and try to answer all your questions and address your comments that way as well. For those of you in the room, in case you need it, the Wi-Fi network is WISPAR Guest. The username is Guest, and the password is Midnight, MIDNIGHT. All right, let's get started. I'm very pleased to introduce our first speaker. Claude Covelli is a dear friend of WILMIC. He has spent 43 years in trial and appellate work, including legal malpractice and professional responsibility defense. Claude is an attorney at Boardman and Clark here in Madison. He's a fellow in the American College of Trial Lawyers, an advocate in the American Board of Trial Advocates. He's listed in the best lawyers in America in trial categories. He is also regularly listed in the top 50 Wisconsin super lawyers. We're pleased to have him here, as I said, many decades of experience to share with us, and we appreciate him being here. Claude is a graduate of Carroll College, now Carroll University, and of course the University of Wisconsin Law School. Ladies and gentlemen, Claude Covelli.
Good morning.
Good morning.
He didn't have to say decades over and over again. Unlike the other speakers, I am not an expert in estate planning. So I started practice in 1972 when associates were expected to work on Saturdays. And every Saturday I would go to lunch with Wade Boardman, who was the head of our firm and was the estate planner. And every lunch, Wade would talk to me about estate planning, but he always started in the middle, and I never understood a word he said. So when I got my first assignment in a legal malpractice case involving estate planning, the estate planner said to me, "Well, are you an expert in estate planning?" And I said, "Well, not yet." And that's basically what I do, is I learn a subject area and come at it with an open and fresh mind, because I'm not bogged down with actual detailed knowledge, and then try to represent the lawyer in question. And what I want to talk about today is a little bit about the difference between OLR ethics questions and malpractice questions, and they are overlapping but distinct. For example, you could have a conflict of interest, which would be an ethical problem, but do an absolutely perfect job for the client and have no malpractice exposure. On the other hand, you may have a conflict of interest and a malpractice problem, and they overlap. So I think some people jump the gun and think as soon as someone has said that they have violated some ethical rule that they have a malpractice claim. That's not necessarily true. I do want to point out that most of you who have malpractice insurance have coverage for grievances, and obviously it doesn't pay damages, but it provides a defense up to a certain sum of money. And if you get an inquiry from OLR, the first step is they receive a grievance, they look at them, some of them they just tossed, but if they're contacting you, that indicates they think there's enough there to investigate. I strongly urge you to A, report it to your insurer, to B, so that you get the availability of the coverage for having a lawyer look at this for you and represent you on the grievance. It also creates a grounds for coverage should this turn into a malpractice claim. And the reason I say this is important is because very often I am retained after the lawyer has responded to OLR. And usually the lawyer that has responded to OLR has not done a thorough review and investigation and makes mistakes in the facts. And those mistakes and facts then become a new charge of not reporting accurately to OLR. So you know, the lawyer who is his own client has a bad lawyer is a really good rule here, number one. Number two, most of you are professionals that have never had an OLR claim or a grievance or anything against you, and you're stunned and you're hurt that your client would turn on you, and you're not going to think clearly. You're not going to see things, first of all, because this is your first time through. Go to your insurer. They have seen every claim, every mistake that you can conceive of under the earth. Nothing is going to be new to them. And it isn't going to affect your premium if you didn't do anything wrong. And if you did something wrong, you want coverage, so report it. There's no deductible if it's a grievance coverage. Your lawyer pays from $1. So if you get the advice of a lawyer, you do your response and it gets dismissed, no harm, no foul, and no money out of your pocket, and you've had the best representation that you could have in dealing with that grievance. Claims made, almost every policy, in fact, I don't know of any policy that is not a claims made and reported coverage for lawyers. And we recently had a recent case on the claims made reported type of coverage. And I don't know if any of you are old enough that were practicing in the 80s when it was really expensive. Legal malpractice insurance was very expensive. Some couldn't even afford it. There were very few companies that wrote it. And it was written like car policies. It was occurrence coverage. In other words, if you had your accident during the policy period, it covered you. Well, if you're an estate planner, your accident happens decades sometimes after you have done the work. It has a long tail, as they say. The claim has a long tail. So accident type coverage, occurrence type coverage was not very helpful because, first of all, you'd have to figure out who was your insurer 30 years ago when you allegedly made this mistake, number one. Number two, your limits would be appropriate to 30 years ago rather than the current state of events. And it was just very problematic and very expensive. So the solution was claims made and reported coverage. And what that simply means is, rather than when the mistake occurred, coverage is triggered by the claim being made, the receipt by the lawyer of a demand for money alleging some sort of wrongdoing. The next requirement is that that claim has to be reported in the same policy period as the claim was made. And what that basically did for people with long tail claims is it shortened the piece of the risk that the insurer was going to insure. It was only going to insure a claim that was both made and reported in that policy period. That made coverage affordable. It didn't take any coverage away from the insured as long as it's promptly reported, because it covered the same risks that the accident type coverage did. So that's why this requirement of reporting the claim in the same policy period is important. And most insurers, in your application for reissuing your policy, because unlike car policies, for example, there is no right to reissue your policy. Every policy is written separately, and you have to apply, and you don't have a right to automatically have your policy renewed. The application will always, I think, ask you, do you have any unreported claims? And you'll be getting that application before your old policy expires. So really look through things, see if there's anything there that you're concerned about. Even if a claim hasn't been made, you can usually report a potential claim and lock in your coverage. And it's a simple matter. You just send, if they get a demand letter, you just send it to your insurer and say, I got this. I just got this letter, and they will take it from there. Okay, the OLR process, as I said, starts with an investigator at OLR contacting you. That investigator may not even be a lawyer, may not have any knowledge in your field of expertise, will ask you a series of questions. There are two types of lawyers that respond. One lawyer will write a book and answer all kinds of questions they didn't ask. Bad. All it does is create more problems, maybe, if you did misstep. Just answer the questions, and then, like I said, do a thorough job. The typical knee-jerk response is, I know about this, and you just sit down and you knock off something and you send it in without reviewing your file, and invariably that creates problems. Even if you succeed and the investigator says, I don't think this is a claim, the grievant can push it and say, no, I want you to look at it further. It can then go on to investigation, and it can go to the district committee, and it can be investigated internally. It can require that you turn over lots of documents. Everything you turn over ends up going to the other side, to the claimant. So it's also discovery for the malpractice claim. So you need to be wary of that. And again, I recommend that you get counsel for that and don't try to do it on your own. Early on, you could get a diversion agreement. Diversion agreements are like first offender school. They're usually for a one-year period. And basically it says if you do go to these seminars like this and listen to somebody like Claude, which is truly punishment, that you don't get another offense in a year, they wipe your slate clean. It's like that grievance never occurred. So you get that option. That is a great option, because if you get even a private reprimand, you also have to pay the costs of the proceedings, which means you have to pay the prosecutor's salary, the referee's salary, as well as your lawyer's pay to defend you. So first offender school is a really good option. Private reprimand and public reprimand. Yes?
Claude, we have a question from a web viewer. She asks, under a claims made and recovered policy, does the insured need to continue coverage after retirement for future potential claims?
Yes. There is what's called a tail. You can buy a tail. In other words, you have these pieces of coverage a year at a time. Malpractice policies are always, it seems, 12 months. So, and you have them back to back to back. Now you're going to retire. All right? So you've got potential claims that haven't been made yet. You can buy what's called a tail for a specific premium, and it can be for 5 years, 10 years, or forever. I think some companies still write them that way. And that means that it picks up claims that are made after you've retired and after you've bought your last policy. So yes, there is a way to protect yourself for retirement or stopping your practice. I don't think anybody will write a tail if you're still practicing. Unless maybe you have coverage with another company, but there would be no reason to do that. It'd be a lot cheaper just to buy a policy for the next year. So yes.
In that same vein, is there any leniency after your own death, or following that train of thought, is there any change after your own death as far as your estate and such? I've heard sometimes you want to have that continue past that time.
All right, let me see if I understand that. You're dead, and now you're worried about the future?
If there's a claim that would
Against
then
your
go
estate.
to your estate.
I believe that first of all, if you're in a firm or a sole practice, usually your firm or your practice is the insured, and you're an additional insured. And I think you could buy a tail for the firm, but you're now talking to me about underwriting issues that I don't pretend to be an expert on. But I believe that you can get a similar tail to protect your estate just as you would protect yourself. Am I wrong on that?
No,
That's right.
It's automatic from us. If one of our policyholders dies, we issue a tail policy for their estate.
It's a successor in interest type of situation. So I think that would work if you had the tail or acquired ones.
But it's important to look at your policy because not all policies are the same. And some tail policies for an estate just cover the estate. The liability may extend beyond the estate even after it's closed. So it's something to look at. And if you can't tell from your policy, call your company.
And I will say this, I've done coverage work for insurers, and late reporting is a problem. And the Supreme Court has now said it's an enforceable problem. So if you have a claim that comes in a month before the end of your policy period, and for whatever reason you sit on it for more than a month, and you get into the next policy period, you're probably going to have a coverage problem that could have easily been avoided by just submitting it. So my rule is, when in doubt, submit it. Submit it. Because if it isn't a claim and it isn't meritorious, it isn't really going to affect anything, number one. Number two, if it is potentially problematic, you get somebody in on the ground floor who has dealt with these issues before. So then you could have won the battle at every stage. The initial investigation, the director's investigation, but they still push it, and you go to the preliminary review committee. And the standard there is that they're not supposed to charge you unless it's clear and convincing evidence. And that's baloney. If it's a he said, she said, or a he said dispute, they charge you. And then it goes on. This all becomes public when a complaint is filed with the Wisconsin Supreme Court. And then you virtually have a trial on that grievance. And it's not the claimant against you, it's OLR against you. And everything is then public, including a private reprimand is public because it's published, because it's a public record. So if you're offered a private reprimand, it is very hard to let that go by because it'll be private. And public reprimands now, the difference between a private reprimand and a public reprimand 20 years ago is a lot different than it is now with the electronic age, where we have all of these AVO and all kinds of systems that report on you and put stars next to your name or black marks next to your name. If you get a public reprimand, it hits the internet, and it is a big deal. And I've been trying to convince OLR and the Supreme Court they need to reevaluate the severity of public reprimands because of the significant effects they have on lawyers' practices, particularly young lawyers. And it's kind of fallen on deaf ears. So lots of things that you need to know. That's why you need a lawyer that's been there and done it and knows the ropes to give you some guidance on what you want to do. There's been some changes that are going to go into effect on January 1, 2017, dealing with clients with diminished capacity. I think somebody else in the panel is more familiar with those issues than I, so I will leave that there. Conflicts of interest, there's a little bit of a difference. I was 3-0 on upholding wills that lawyers drafted that they were the primary beneficiary. That has kind of dried up because they've added to the rule that you have to be a relative. The lawyer has to be a relative before they can take under a will they draft or a document they draft. So the issues are the same. I got to play cards with ladies in their 80s to gather witnesses for those cases, and I kind of missed that. That was kind of relaxing. Really good cookies. And then the communication rule, and I want to just touch briefly on, you've made a mistake, okay? You have a duty to communicate with your client about that. You don't have a duty to fall on your knife and say you made a mistake. You have a duty to tell them, this is what happened, this is the result, these are the options, you should get other counsel, all right? You don't have to say, I really blew this, I don't know what I was, I was drinking that night, I don't know, gee. You don't have to do that, all right? Number one. Number two, don't try to fix the problem because you have a conflict, right? Your interest and the client's interest, if you try to settle this dispute, you have a conflict, you may just make things worse. So what you need to do, tell the client, well, first you need to tell a lawyer, hire a lawyer, have them look at it with a fresh set of eyes. You may not have a problem. I don't know how many cases, I had a lot of statute of limitations cases where lawyers thought they missed the statute of limitations on a claim, and they didn't, because that was the first time they had to face that issue where the insurance company sees that issue regularly. So get help. They will help you draft the letter. I recommend that you have the client come in and you sit down and you hand them the letter and you talk to them. And it wouldn't hurt if your secretary sat in or some other witness sat in so there wasn't a dispute about what was said. Communication and who is your client? I think that's an issue with estate planners. Mom comes in and she has in tow her children. And you ask and mom says, yeah, I want them here. So you think, Mom is my client, and her children are present. The children may be thinking, he's my attorney, or she's my attorney. And the attorney-client relationship is essential to ethical charges as well as malpractice charges. And communication here is important. It is important not only that you communicate it orally, but that you communicate it in writing. Because sometimes these pseudo-clients, the children, forget what you said or don't want to acknowledge what you said. And that's why it's important that you have it and that you didn't send it only to mom, but that you also sent that information to the children. All right? So an attorney-client relationship, how does that develop? Well, it doesn't necessarily require that you send them a bill, i.e. you send the bill to mom, but the children are there, and they're claiming that they were clients too. You never sent them a bill, and you say, well, I never sent them a bill. And as you think that helps. Well, it's helpful, but it's not determinative. You're better off if you had written a letter that clearly informed them from the get-go that they were not your client, and that you are not representing their interest. And that is another situation. Mom comes in with her son. Her son is sophisticated, she says. She's in her 80s. She says, well, do whatever he wants. Is that enough? So the son wants this complicated deal so that he might be able to avoid some sort of tax. Is that enough that mom said do whatever he wants, and then you communicate with the son, and then you bring it in and she signs the document that she never really understood? Is that meeting your obligations? I would say no. I think you need to explain to her what is going on so that she understands what she's doing, and she can confirm with her son that that's what he wants. So that gets complicated. And then the question is the son the client now? Because you're doing what the son wants. And so I think these are issues that estate planners run into all the time. And let me give an example, a case that I had some years ago. We had a lawyer that mom comes in and says, I have 3 daughters. I want to create a trust where the daughters share equally in my estate. The lawyer does that work, finishes that work appropriately. Then one daughter comes in and says, Mom wants to disinherit Sally. And the lawyer says, well, gee, I'm representing Sally in something else. I can't do that. So mom and other daughter hire another lawyer. And the other lawyer goes about taking steps trying to cut Sally out, but misses some assets that Sally is a beneficiary on. And this is part of my lucky sperm, I should say lucky egg, maybe now to be fair to both sides. I have never seen such bitter fighting over money that nobody earned as beneficiaries fighting over money. It's just incredible, the angst that I think. And it must be, I thought it was greed, but I think it's more than that. I think there's some underlying, this is a symbol of whether mom loved me or whatever, but it's just amazing. And it require large amounts of money even, but the fight really goes on. So anyway, they hire this other lawyer, but the lawyer misses some stuff, so Sally gets some of mom's assets. So they sue the lawyer that was hired to disinherit Sally, but they also sue the first lawyer, the lawyer who had done what he was asked to do, which was to make an equal division of these assets to the 3. So the first question was, because somebody said mom, who he had worked for, wanted him to change what he had done, did he have a duty to do it? Did he have a duty to represent mom in disinheriting Sally? Anybody think he had a duty to do that? Good. Nobody here? Those of you that are watching on video, we won't know if you raised your hand or not, but the answer is no. The fact that you once represented a client and that work is done does not obligate you to take on a new representation. And in this case, where they are asking to disinherit an existing client, it would have been a conflict to do so. So the argument was the lawyer, the first lawyer, was negligent because that first lawyer did not provide the second lawyer all the information on how the assets have been distributed under the trust. All right, so the first lawyer should have given the second lawyer the information that would have disclosed that Sally was still a beneficiary on some of these assets. But the second lawyer never asked the first lawyer to turn over mom's file, and mom never sent an authorization to turn over mom's file. So does anybody think that the first lawyer had a duty to turn over information about assets to mom's second lawyer? Good. I don't think so. Now, if there had been a written request from mom to turn over her file to the second lawyer, I think that lawyer had an obligation to turn over that file. But absent that request, the lawyer had no reason to believe they needed the file or wanted the file. So that was a case where an expert said that, yeah, there wasn't a client. Yes, he didn't have a duty to take on the new representation, but he was negligent for not turning over the file, or not turning over the materials that weren't asked for. Yes?
Claude, another question from a web viewer. Does the first lawyer have a duty to talk to mom to determine what her wishes really are?
No. You don't want to, because mom is not your client. So, and that was one of the main defenses that we had in showing that mom wasn't the client, was that the lawyer had no direct information from mom whether she wanted to cut Sally out or how she wanted to cut Sally out, that mom had never actually come to her. The initial request came from another daughter and was immediately told, I can't do it, I have a conflict, I'm not involved. So my answer to that question is no. You don't, because if you're doing that, you're acting like mom's lawyer. And you can say, I'm not your lawyer, and that do things that a reasonable client might interpret as meaning you're their lawyer and become the lawyer by what you do. So you don't want to do anything that would appear to be acting as somebody's lawyer. So I would say no to that. And again, you would write a letter saying, if you were really on your toes, I can't talk to you about this, I'm not representing you on this.
And if you did, you'd be breaching other ethical violations about talking to a client behind their lawyer's back, because they now have a new lawyer.
Well, even if the new lawyer came in with mom, I'm saying you just don't want to go down that route. Now, if they ask for their file, that's their property. That's a different matter. Then you need to turn over an accurate copy of that file or the original, and you keep a copy depending on what your practice is. But the scope of engagement, you see this also in trusts and funding of trusts. Some lawyers believe that you can't do a trust without handling the funding of the trust, that it's malpractice not to fund the trust. Many other lawyers believe, no, you can set up the trust and you can allow the client to fund the trust. And again, how much instruction and how much information you have to give the client who is going to fund their own trust is matters that lawyers will dispute. But if you are not going to fund the trust, you need to say so in your initial engagement, that this is what I'm going to do, this is what I'm not going to do. This is what I'm going to charge you for, this is what I'm not going to do and not charge you for. Even if the other side then is arguing you had a duty to fund the trust, you're a lot better off if you have a clear correspondence and established relationship with the client that said you were not going to do that. And again, that's communication and that's documenting your file. And I know sometimes we feel like it's insulting to the client to tell them something and then write them a letter saying the same thing, like you don't trust them. But it is important that you have it in writing, because if you don't, they're going to say, well, they're a lawyer. Why isn't it in writing? Why should we believe them? Certainly the client wasn't going to write a letter and say what their understanding was. If anybody was going to do it, it's the lawyer. So I've seen problems there with trusts and the funding of trusts and the distinction of what was part of the engagement. Another issue, do any of you charge flat fees for any estate planning work? Okay. Flat fees are a difficult area, particularly in OLR. They aren't a problem if the work gets completed. It becomes a problem when the work doesn't get completed. For example, you agree to do a trust for X dollars, and somewhere along the line, the client gets dissatisfied or changes their mind or says, I changed my mind, I don't want the trust. So now you've got almost everything done except signing the documents. And now the question is, how much of that flat fee do you get to keep? And depending on how you set up a flat fee, it can be something you put in the trust account, or it can be something that you put into your bank account. But regardless of the way you do it, you need to do a final accounting. And if your work is done, it's simple. You say flat fee to do X, X is done, your fee is X, what was agreed on. When you don't finish the project, it's a mess. The rule says you can't bill by the hour. OLR says you can't charge more than your hours in it. And I said, well, wait a minute. The rule says you can't do it by the hour. And that's where we are. It's a total mess. And theoretically, you look at the percentage of the work that was done and the percentage that wasn't done, and you're supposed to calculate it out. But it is very difficult to establish what part of a flat fee should be retained when the work isn't completed. And I haven't seen anybody that, and OLR has a form for flat fees to comply with all the rules on flat fees. It'd be worth looking on their website if you're using a flat fee, because usually I find criminal lawyers, I'll talk to them, they say, well, yeah, I used John Jones's form, and John Jones has been dead for 40 years, okay? So a lot of things have changed in our OLR requirements and ethical requirements in the last 40 years. So it wouldn't hurt to check your current flat fee arrangements with the current rules to make sure that you're dotting all the I's and crossing all the T's. So I could tell you, never have sex with your client. I had one guy that lived with a woman for 9 years, and the question was whether he did work first for the client and then had sex with her, and where they became their long-term relationship, or whether they had sex first and then he did some legal work. And the fact that he lived with her for 9 years, it was a continuing foul. They said OLR, and I said, well, gee, it's a good thing he didn't marry the woman, because it would have gone on forever until they were divorced. So that kind of a conflict of interest, I think, is readily apparent. But it is one that involved 5 years of litigation with OLR, if you can believe it. Some of these OLR cases will go on for 5 years because you have at least 4 levels of investigation followed by a trial. And if you win everything, I've had cases where they want to pull the person's license, and they end up with a private reprimand, and because they were found guilty of one thing, ended up paying tens of thousands of dollars of costs to OLR, as well as paying their own lawyer to defend. So these are heady decisions that you need to look at, and you need to make sure that you're doing the right thing. If you get a grievance, there is a rule that says you are not to interfere with the investigation. And this gets a little thorny too, because, for example, I had a case where the lawyer says this case is settled, the client files a grievance saying, hey, I didn't say he could settle the case. And the lawyer is still representing that person in litigation. Now the lawyer's saying, well, if I talk to the client, am I interfering with the investigation? And I always say, you write to OLR and say, I need to talk to the client, we have this ongoing thing, is that a problem? And get their consent. They usually almost always say no, you can talk to the client. But I think it's dangerous unless you have somebody present with you, and then you run into the conflict issue now. In other words, if you talk to the client and proceed with the settlement, are you protecting your interest, or are you protecting the client's interest? So it gets complicated, and again, I recommend that you get an outside help on that before you try to resolve something. And it's always best if the client gets a new lawyer to represent them, but often they don't. They often don't. And even though they're filing a grievance against you, they're telling you they like you so much. It's really a complicated matter. Any questions that I can answer? I got 3 minutes, I think. No? Am I over?
No, you actually have another 30.
Oh, I was too concise. Well, yes.
I may have missed it, but, you know, when I came in, you were talking about when you agree to do a flat fee basis with your client, and then the trust or whatever doesn't get completed, the client doesn't sign it. Is it possible to, I mean, if this happens to you once, I think you'd change how you do your fee agreement. Can you make an agreement with the client that we're doing this on a flat fee basis? However, if I get this to a certain point and you don't proceed with it where you've done everything as the attorney that you possibly could, can you then, in your fee agreement, say, all right, then the fee basis shall shift to an hourly basis?
Okay, the question is, can you draw a flat fee agreement that says if for some reason, presumably not due to the lawyer's misconduct,
Right.
the transaction isn't completed, in which case it will be billed on an hourly basis? I think not, because the rule says you can't bill on an hourly basis if you've agreed to a flat fee. I think what you could do is you could say the total flat fee for completing the project is X. The flat fee for doing the investigation and initial draft is 20% or 50% or 70%. And do it in stages that gives you some at least partial protection, and it would be something that the client would be signing off of in advance, and that's critical. You can't do this after the fact. It has to be all part and parcel of the agreement. And then you always have to, on a flat fee, you always have to do an allocation and a statement to the client, an accounting, where you can say, okay, the flat fee agreement says this, you've decided to terminate, but we've reached this stage, therefore the flat fee is X, and it's nice and clean. I have never seen anybody yet do that. So I think everybody takes that risk instead, but I think you could do it, and I think it would be binding, and as long as it was quote-unquote reasonable. You couldn't say after initial conference you owe us 90%. That wouldn't work. Yes?
Claude, we have a web question. You mentioned a flat fee form from OLR. What does that form address, and where can we find it?
I can't give you the website, but I think if you go on OLR's site and check, I think you can find, and I will do this, I will give that information to WILMIC, and you can call in and they will make that available to you. But it basically deals with what the flat fee is, what the flat fee is for, the fact that you may have stuff in there about if there's a dispute, how the dispute will be resolved. It'll provide for a final accounting before the taking of the fee. It will also provide for whether or not it is the type of fee that has to go into your trust account or whether it's a fee earned that goes into your business account. So it covers a lot of things. And like I said, it touches all of the I's and dots all the T's. It crosses the T's and dots all the I's. But it doesn't deal with this partial thing that we just talked about in this answer, and that's something that you would have to add over and above that to break that fee into parts if you want to do that.
Where you're an attorney that believes in funding revocable living trusts, and you go through the process, you send out everything, and somewhere down the line there's one or two assets that always just don't seem to get done, and you send multiple letters to the client explaining to them you can't go forward without getting their help, getting things done. At some point in the representation, can you say, I'm done, I can't move forward any further with you, you're on your own with this? Or does it require consent by the client? Do you have to get a letter from the client signing off on it at that point?
All right, so the question is this. You've got 80% done, you've got a couple straggler assets out there, but you can't do your work without getting information from the client, and it's simply not forthcoming. And you've made repeated, documented attempts to get that. Can you withdraw from that representation without the client's consent? And I would say yes. If you can show that the client's non-cooperation has undermined your relationship so that you cannot do your work, I think that you can, because after all, if that client kicks off and goes to the next world before they cooperate, the kids will be looking at you, coming after you for these assets. And I would do it with notice. I would say to them, if you do not provide this information by X, 2 weeks or whatever a reasonable period of time is, I will have no alternative but to withdraw from further representation of you in this matter. I recommend that you obtain other counsel, blah, 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 and maybe even tell them about what the repercussions of not providing that information is. And then when they don't comply, I would write a second letter saying, I wrote you on such and such, here's a copy of my letter. You have not provided that information. I deem that your intent to terminate our relationship, as I said in my earlier letter, and therefore I am no longer your attorney with respect to this matter, and strongly urge you to retain other counsel to complete this funding of your trust. I can't guarantee you that somebody won't sue you for that, but I think you would have a fairly strong position in defending that claim, because it would be like representing a client who refused to follow your instructions. You just can't do that. You can't handle that. You can't represent that person. And that leads to another situation, and this is mostly in civil cases, but there are a few things that the client has absolute control over. The lawyer can't make the decision to settle, for example. Lawyer can recommend and suggest and advise, but the client makes that decision, not the lawyer. So the lawyer can't say to the client, you must do this. Or the client says to the lawyer, what do you think I should do? And you say, well, I think this and this and this, and this is why. okay, and then the client says, well, then you make the decision. And then you say, no, I cannot. You must make the decision. I can give you guidance, but you must make the decision. And when the client makes a decision contrary to your advice, it's important that you document your advice and write the client and say, you have decided to do so-and-so. I have recommended that you not do so-and-so for these reasons, boom, 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 boom. However, this is your decision to make, and therefore I am following your instruction. And provide them that letter before you act, rather than after you act. So I think that is important, that documentation, people say, how long should I keep my file? That's another one. All right, I would say until all risk has terminated. And for some of you, that means you will have a big warehouse of files. And sometimes that documentation is very helpful. Sometimes it's not very helpful, and you wish it had been destroyed. But the point is, it's the facts. It is the facts. And even if you haven't written a letter, if you have contemporaneous notes of your conference, that's helpful. That's helpful, because if it's the person's word against your word, and you don't have any sort of documentation, the tiebreaker usually goes to the client, because the jury relates to the client, not the lawyer. And the lawyer, you know, we eat our young. Lawyers sue each other readily. They all say the same thing. Well, they're the lawyer. They should have the proof. They should have the proof. So document, document, document. One last thing that I want to talk about, and that is this new, and I'm not going to talk about the details of it, but the new rules that go into effect talk about diminished capacity. And it says, when a lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonable necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. I emphasize the word may. I see that as a quagmire. I really do. In making a will, the standard for competence is very low. And if you're going to turn in, I don't know how else to say it, turn in your client and say that your client isn't capable, isn't competent, and needs a guardian, I think you're putting your name on the defendant block of a civil action by your client against you. And you better have all your ducks in line, and trying to tell a jury you were doing this for the benefit of the person that's suing you is a tough row to hoe. So I think the word may there is critical, and that unless there was just absolutely no way around that this person needs a guardian or a protection, I think, you know, and you would, well, first of all, you would have to try to explain to the client they need a guardian, but you're explaining to a person that you think isn't competent. I mean, you know, so then, you know, do you go to the children? Well, of course not. You're breaching confidentiality. Although this seems to say you can consult with individuals or entities that have the ability to take action to protect the client. I'm not sure what the breadth of that is. So I think before I did that, I would consult with a lawyer and get some independent advice.
Going back to that question about the hourly and then converting to the flat fee converting to an hourly, I've seen that type of situation in bankruptcy fee agreements very often, because you'd have a bankruptcy that would be your basic bankruptcy, but if a motion is filed by a trustee or other party, then it might change into an hourly type basis. But
Okay,
what I've
that's a little
seen-
different.
Okay, but what I've seen is then you're executing a second fee agreement to take on that additional representation, and it says that right in the initial fee agreement.
Right. Okay, let's distinguish the difference here. If you have a flat fee agreement, it's critical that you precisely define what you are doing for that flat fee. And what we're talking about, I think in the bankruptcy context, and correct me if I'm wrong, is it says these things are not part of the flat fee. If there is an objection to discharge or something, that will be dealt with separately on an hourly basis. That is very different from saying, I will do X for a flat fee, and if we don't complete X, it's going to convert to an hourly rate. I don't think you can do that. But I think what they do in bankruptcy court, they can do, and they'll say, well, what I'll do is I'll do A for a flat fee, but I'll do B, C, and D on an hourly basis if it arises. Because in bankruptcy, you don't know that those things will arise. So basically, they're doing for a flat fee the basic filing, saying that if these other things occur, I'll charge hourly. And I see absolutely no problem with that. It's converting something you've agreed to do for a flat fee to an hourly that I see the problem with. And, and I depose experts immigration is another area where they use flat fees. Criminal law and immigration, you want to get a green card, they say we'll do that for X dollars. And they do it on a flat fee, and usually they do it on a flat fee that it just goes right into the business account, but you still have to do an accounting. You get to the end, and they don't want their green card, or for whatever reason they can't get the green card, they don't want to pay anything. And I've deposed experts for OLR, and they said, well, how many hours did they have in? And I said, well, let's say the flat fee is $2,000 at $200 an hour, and they have more time in, and they've got $2,500 of time in. I said, did they get $2,500? Oh, no, but they would get to keep their whole fee. I said, well, wait a minute. The work's not done. He goes, oh. So hourly, that conversion just doesn't work. And then they say, okay, well, then let's look at how much is left and how much a lawyer will charge to finish what's left. I said, that's just hourly by a different name. So I think our court has got to straighten all that out at some point so that we have a clear rule and understanding of what happens when the work doesn't get completed under a flat fee, and how is it going to be allocated. And I think the answer here is very good, and that is you break it up and you say, if we get to this point, it's X percent, at this point, it's this percent, and so forth, because if it's not clear in the agreement, the lawyer generally loses. Or at a minimum, you end up in arbitration, or you end up in front of the OLR having to fight out how much the fee is.
Claude, back to the file storage issue. A question from the web: what do you do with your files after you retire and no claims have been made? And I think you kind of addressed that, but this isn't a retirement situation that she's referring to.
Well, I have that situation right now with a lawyer that has trust account money and has files relating to trust account money and files not relating to trust account money, voluminous files, sole practitioner, and going to retire. And the question is, well, what do I do? There is a statute that allows the state to step in and assist a lawyer in wrapping up a practice. But I think the files, to the extent they are worthy of being retained, you would probably have to find the client and give them back to the client. Or hang on to them, or have somebody hang on to them until they were capable of being destroyed. The same thing with trust account monies. You have money in the trust. You can't find your client to give them their money because you had to hold it for X number of years or some reason. And you want to retire. You either have to go through the escheat process, which requires all kinds of paperwork, let me tell you, and you have to show that you haven't sat on your haunches too long, or they'll fine you to boot. So, but you can't go away and have money in your trust account. So it's a real dilemma, yes.
With regards to the files, though, nothing prevents you from scanning the files into an electronic format and destroying the files as long as you keep a copy, correct?
Sure.
So as far as these voluminous files, they don't have to be voluminous. They're choosing to keep them voluminous.
Well, you know, but converting a warehouse full of paper files to electronic is not cheap either, but it might be cheaper than maintaining storage space or trying to find the clients to return their files to them. And then there's also the question of what part of the file do you need to retain. You know, if it's a settlement of a case, you may need to keep the release and the closing papers and the allocation of funds and whatnot, those documents, and be able to destroy all the medical records and everything that might be in the file. The same thing, I think you can sometimes winnow down what you need to retain. But yes, you could electronically, as long as you have them, you know, and then I would keep 2 copies and have one in a safe deposit box and one maybe in your office just so they don't, you know, electronic files get destroyed. I know a law firm had a fire and their electronic records were in the basement. And fortunately, most of them were able to be saved, but what a disaster that would have been. All their calendars and everything was potentially lost. And you know, the other thing is the rules talk about lawyers having, part of your competence is knowing about all these electronic details and how you can keep confidentiality and keep this information stored. So you have to do some work, homework, and make sure that what you're doing keeps this information confidential, or if there is risk of loss of confidentiality, that your client knows about it and decides this is the way they want to communicate, and someone files a grievance, you need to stop and make sure you don't destroy emails, or that, you know, you may have automatic destruction of emails after a certain period. You need to preserve that information so that no one's going to claim you spoliated information once you know that there's a claim. So when I started practice, court reporters had pencils and a pad of paper. Now they come in with a computer. Secretaries took shorthand. And now it's all electronic, and you know it's a very different time, and we just have to keep up with those changes, or we're going to get in trouble.
Any other questions for Claude? All right.
Well, let me see. Just one final thing. So, what happens if someone files a grievance? call your insurance company, right? If not your insurance company, don't call your best friend. All right? First of all, you probably don't want your best friend to know. Secondly, you want somebody that's been through the cut. Call your insurance company, get help, respond. Don't ignore it. That is the worst thing you can do, is ignore it. And get help right away. And 9 times out of 10, it's a false alarm. It is a false alarm. Thank you very much.
Thank you, Claude. It's about 10:05. We'll take a 15-minute break and then come back at 10:20 with our panel discussion. Thank you. All right, we're back. Thanks to all of you for coming back. We have the second half of the program now. A couple of housekeeping matters. Number one, I did not mention at the beginning, although most of you probably already know, this seminar has been approved for 3 ethics credits. Number two, I understand for those of you on the web, you were not asked to sign in as you normally would be asked to do. We have had some inquiries about that. Don't worry about that. It is recording the analytics, so you will be marked as attending based on your IP address. And so when you report this seminar for your credits, you will be given credit for that. So don't worry about not signing in this morning. All right, let's move on to the second half of the program. First, thanks to Claude for a very good first half. And I encourage all of you to keep the questions coming. Our panel and Katya will do a good job of addressing those as they come in, both for you here in person and those of you on the web. Now, our panel, to my immediate right, Gregg Auby. Gregg is a shareholder in the Sun Prairie firm of Eustace, Slaffy, Sobranek, and Auby. He got his law degree at UW in 1994. Gregg concentrates his law practice in the areas of estate planning, probate, and trust administration. He is a member of the Dane County Bar Association, the State Bar of Wisconsin, the ABA Real Property Trust and Estate Law Section, and the Madison Estate Council. He currently serves on the board of directors of the Madison Scouts Drum and Bugle Corps and has served previously on numerous local board of directors. So we welcome Gregg to our panel. To Gregg's right is Kevin Demet. Kevin is a lawyer in Milwaukee. He does complicated legal work on behalf of individuals and businesses, including civil litigation and transactions involving financial matters, trust and estate planning, insurance, real estate, business, and employee benefits. He also handles class actions, employee benefits, guardianship, and consumer fraud cases, trust, estate, and will litigation, insurance claims and lawsuits, and commercial disputes. Kevin has argued several appeals as counsel of record, including before the 7th Circuit Court of Appeals, the Wisconsin Supreme Court, and the Court of Appeals. He earned his BS from Marquette and his JD from the University of Wisconsin Law School. He is licensed to practice in Illinois, Wisconsin, and numerous federal courts as well. Kristine Snow is to Kevin's immediate right. Kristine is currently a shareholder at Snow Law in Waupun. She practices law with her husband, attorney Todd Snow. As attorneys in a small town, Kristine and Todd assist individuals and families in many different areas of law. Kristine focuses on family law and bankruptcy, estate planning, probate, guardianships, and other related areas. She also has participated in many appeals, including 2 arguments before the Wisconsin Supreme Court. She is well versed in the special challenges that may be presented representing clients with physical disabilities, mental disabilities, and cognitive limitations, and we'll get into some of those issues as the panel discussion goes on. Kristine grew up in Columbus. She is a 1992 graduate of UW Law School. And Claude is going to join our panel as well. And I will now turn it over to the president and CEO of Wisconsin Lawyers Mutual Insurance Company, Katya Kunske. Katya has been with WILMIC now for 27 years, I believe. So, all right, Katya, take it away.
Thank you. So I just want to make an observation. In your materials, we talk about the panel discussion dealing with unhappy beneficiaries and broken families. You don't like broken. I like to think of them as interesting, having enjoyed 2 divorces myself with a child from each, and they're 14 years apart. So my estate plan is fairly interesting. So we'll call them interesting families, but they do raise really interesting claim issues. Claude referred to that earlier. You've got multiple marriages, you've got children that are full siblings, half siblings, step siblings. There's a whole lot of money that is passing from the boomer generation. So nationally, among lawyers, professional liability carriers, we are preparing for a wave of legal malpractice claims in the estate planning area between the amount of money that's coming, estate plans written at times when tax consequences, for example, were different, asset values were different, families were different, and then dealing with it. And then the issue that Claude also pointed out, which is a lot of times this is not about money. It is about Mom liked me best. And maybe the estate plan shows that, and that's painful. And it shows in the claim and the complicated resolutions of the claim. So I want to start with diminished capacity. Claude talked about, who is your client and how can you represent multiple family members and why should you not represent multiple family members. But I want to go back to this diminished capacity issue. Kristine, you deal with this. So how do you know? What's okay, crazy, and not okay?
One of the things I think is when you meet with a client to have multiple discussions with the client at different times and see whether their demeanor, their rationalization changes, and ask them questions that get to the meat of their thought process behind the decision. So if they say, I want to leave everything to Jody because she takes care of me and I want to leave out Jimmy because I haven't talked to him, talk to them a little bit more about that relationship. How long has this been going on? What has been going on behind the scenes to find out if it's really a rational decision or if something is impairing that. And usually it's pretty apparent if their thought processes are pretty disjointed that they might be suffering from some mental illness or dementia or something like that, or if they have a rational thought process behind it.
Okay. Anybody else here have something to add to that?
I've run into this a couple times where I wasn't sure, and I've actually made the client go get a medical opinion that they were competent to use it. And in one particular case, she died during the litigation, and then we ended up, but before she died, they tried to commence a guardianship proceeding against her, which got thrown out of court. And then there was an ongoing litigation for an accounting of a trust and a power of attorney that eventually was resolved successfully for the children. But the medical testimony we had was very powerful. Just having that written opinion, the doctor never even had to testify. It was enough. So if you feel that you're uncertain, that's one step you can take. It's not a big investment of money if the client's willing to do it.
Yeah, I think that's a really good suggestion. Let's talk about what coercion looks like. Gregg, have you had experience where a client appears to be being coerced by somebody?
I have, and it's not too difficult to identify that in my experience. And it gets back to what Claude was talking about in identifying the client. I don't personally practice in the elder law area, but I do not envy elder law attorneys who get the call from prospective clients' daughter saying, my mother wants to give me her house. And then trying to proceed from that point and identify who the client is. But that's a pretty obvious indicator, I think, that there may be some coercion or undue influence involved. If you're meeting with the family together, whether you think that's a good idea or not, we can talk about that later. I think you can get a pretty good gauge on whether the prospective client is making his or her own decisions. Not uncommon for elderly prospective client, before answering a question, to look to their left or look to their right, thereby identifying which child they trust and who may be making decisions on their behalf instead of making their own decisions.
But sometimes it's right. I mean, they do actually trust. I definitely trust one of my kids more than the other one.
Well, and as we were taught early in law school, it depends. It depends. If it's elderly client with single child, adult child, and the stated objective is probate avoidance, assistance with facilitating the execution of a revocable trust, leaving everything to adult child, that's one set of circumstances. If there are 4 children and one of the children is with mom in the meeting, and mom is saying, potentially under coercion, that she wants to benefit present child to the detriment of others, then you have a problem.
Right. What do you do?
Well, at that point, I think, as Claude mentioned, you for sure need to identify who the client is in writing. And then you have to be careful about fulfilling your ethical obligations after having identified the client. It's not uncommon for me, even at the initial meeting, to ask family members to leave, even if their loved one would feel more comfortable with them being in the meeting. So hopefully you can just develop some trust with the prospective client so that they reach a comfort level where they're okay with loved one leaving the room, so that we can have a more candid conversation.
Sure. Anybody out here have experience with that? Yeah, hang on.
I'll throw a twist on it. Fact situation in some is a grandmother living in her own house, becoming infirm both physically and mentally. Granddaughter moves in and it's fairly much not disputed that, or I shouldn't say, it can't be refuted, that the granddaughter's been ripping off grandmother to the tune of 6 figures. I'm then appointed. A guardianship petition is filed in this situation by the county via elder abuse. Grandma objects, saying, I don't need a guardian, and if I do need one, I want it to be my granddaughter. And it's absurd that she would be ripping me off. I'm appointed by the court to represent grandma. I know who my client is, there's no doubt about that. And the granddaughter is cooperative to the extent of my being allowed to visit with grandma without, at that moment in time, the granddaughter having influence. I can meet with my client alone, but persists in saying she's not doing anything wrong and I'm perfectly fine. Doctor's report says she has dementia, needs a guardian. Now, I think I know what the answer is, but I've been doing this long enough, I think I know what the answer is. That works for me. But how vigorously do I defend the petition when I know, if I prevail, which I won't, that I'm selling my client down the river to continue to be ripped off?
Is there a guardian ad litem appointed?
Oh, yeah.
Okay.
That's what prompted me getting appointed.
Okay.
You're the guardian, or are you the lawyer?
I'm the attorney for the proposed ward. Pardon? No, I'm the attorney for the ward. There is a guardian ad litem already, which prompted me getting appointed.
Right. And that's hugely important because, as you know, the guardian ad litem is representing the best interests of the ward.
I know how it should play out.
Right.
Okay.
Well, and that's why that piece needs to be in place. I don't do much in the guardianship area. I don't do much in the elder law area. But when I did 20 years ago, heavy reliance on the role of the guardian ad litem, because that's what the guardian ad litem is charged with doing. And they're in a better position to advocate on behalf of the best interests. You have a responsibility to zealously advocate on behalf of your client.
That's the problem. You know, I zealously advocate, but does it mean we go to at this point it would be a temporary guardianship hearing? I've got nothing fact-wise to refute the allegations. I think the limits of my zealously advocating is to say I object and waive further argument, because I'm protecting my client's interest, notwithstanding her statement that this is all nonsense. Fine line. I don't know where you draw it.
Well, I think the objective is the client's decision. And if the client wants to resist, I think that's your obligation. I had the first Lessard case in La Crosse County where I was defending a woman who looked perfectly sane, except she literally thought she was the wife of Christ. And so I refused to let her be interviewed by any of the psychiatrists, and they lost, and she was on the street and coming to my office regularly after that as payment for my good work. But I think my job was to achieve her objective, which was not to be committed at that time. And I had a tool. I thought she should be committed, but I had a tool that I could use to accomplish her objective, and I didn't think it was my role to substitute my objective, which I might even think was in her best interest, over hers. So I think that is covered by the rules, that the objective, the goal, is the client's decision, and how you get there is the attorney's decision.
One of the more interesting things in my thousands of estate plans is what I refer to in the office as the yo-yo effect, where the older client comes back years later with the favorite child and wants things changed in favor of the favorite child, and the following month they return with a different child who is now the child of the month. And this can go on and on and on, and that's a very intriguing situation. And we also have to realize that some of these older people are also playing a game with their kids. And it's, if you're not good to me, you're out. In other words, you yelled at me, you disagreed with me, you didn't do what I wanted, you're out and Sally's in. And these are all things you have to be able to pick up in representing these clients. I'm interested in the panel if you've had that yo-yo thing and how you handle it.
Oh, Kevin, you took a breath.
Put the foot out. Yeah, they're tough. These are tough situations. Anytime you're picking a winner and a loser, as a lawyer, you're setting yourself up to be a witness and possibly a defendant in a lawsuit. So my strategy number one is always talk them out of it, okay? And then have a really good reason for doing what you're doing. And then don't make any quick changes and most people do want to be equitable and fair in their estate plan when you actually talk to them. Even if they want to favor one, they don't have to favor them wholeheartedly. In other words, they can do something extra for someone without completely taking out someone. Because once you take someone out, you're setting yourself up, I think, for a lot of problems down the road.
Kristine, how about you?
I don't know that I can add a whole lot more to that. I think the suggestion that you should do it over time is important to see how much they're flipping and flopping on that, and what their justifications are for making the changes. If it's just that Johnny didn't bring lunch to me yesterday and I'm going to write him out of my will, I think that could be an indication of some bigger issues than just a power play on the parents. It could be a mental issue as well. But getting to know your client a little bit, I think that's important. I don't know how much as lawyers we can do that when we're charging lower flat fees for some basic estate planning, so that makes it difficult too. But that also means that's a reason why people don't understand why it costs more to go to a lawyer than it does to do something on LegalZoom, and I think that's important to explain to them as far as why we justify the fees that we do.
I have a fairly mean mother who has an estate plan, and she will, this was drawn up a good 10 years ago at your firm, Claude. And she periodically gives me envelopes with pencil scribblings on the back that make changes to that. And every time she gives that to me, I say, this doesn't mean anything, all right? You need to actually change your will if you want to change. You know what I want. You people, you just make sure that happens. So my brother, who she loves more, I have a bunch of envelopes, and I may or may not give them to the lawyer when my mom goes, what do you do about a client that is just kind of mean? Not crazy, not coerced, but just wants to do some kind of mean thing, that last whack after they leave this earth.
You don't have to carry it out. I mean, you don't have to represent them. And then if you do, well, there's a famous case, the Washington Post guy who started the Washington Post. Can't think of his name, Graham. Yeah, his wife, at some point he went mentally ill, but he owned the Redskins and everything. He was a big guy in town, but he cut her out of the will. And so I think Edward Bennett Williams, who's not an estate lawyer, wasn't a probate lawyer, wrote a will for him and then went back to his office and drafted a memo saying the guy was crazy and it was absolutely unenforceable. And when he died, his will was not probated, the new will.
The new will, the mean will, the crazy.
Yeah. It was knocked out of the box.
Was the lawyer's memo evidence?
Yeah,
or?
Absolutely.
Wow.
Yeah.
As a malpractice carrier, if you have that mean client, certainly the crazy client, but absolutely the mean client. This is the one where Claude's advice about you write it down. If you give them some advice and they don't take it, and you're still going to be their lawyer and you're going to do what they instruct you to do, which is counter to your advice, please write that down.
We had a client who wanted to leave one of their loved ones 5 cents.
Which is worse than nothing.
Right.
Yeah. It's the nickel tip.
And what's interesting is it brings up a whole host of notice issues then as well in the probate proceedings. But we thankfully were able to talk the client out of doing that.
I think my mom switched forms on me. Yes, hang on, wait for the microphone, please. Here you go.
When Kevin mentioned, the situation where you go back to the office and you write the memo that the client you didn't think was competent, what about the witnesses who executed that will?
That's a problem, too. You know, honestly, you want to get these people out of your office. The amount of fees you make in an estate plan is not that large a sum, and some of these people are just trouble. I remember doing one years ago. I had 2 doctors in my office. They had 3 pieces of real estate, virtually no cash, but the one doctor was supposedly a great money manager. They wanted to keep these vacation properties in northern Wisconsin, Maine, and somewhere down south forever in perpetuity, and then the kids had to do STD tests and stuff to get their inheritance. And and of course, when you start telling them their plan's crazy, they don't want to hear it. And so then at that point, you either keep going or and you assume the role of getting pulled into their family problems, or you get out of it. And I just, a lot of those ones I elect to pass on. Now, if it's an extremely wealthy client where all that time that you're going to put into doing file memos and making sure that everything, well, then maybe you want to spend some time on it, but cover yourself, do those covering memos. But covering memos look funny when you're looking at your file later too, because it looks like you're trying to hide something, or you're trying to, so they're not always completely going to get you off the hook of problems.
No, they're not perfect, but I assure you they're better than not having something like that.
If you're going to write a memo that the will or the document you drafted is ineffective because your client's a brick short of a full load, you better communicate that to your client, I think, because I can't imagine anything that is more pertinent to the work you're doing than that it has no effect. And I think this lawyer, if he did not communicate to this fellow that I just drafted you a will that isn't worth the paper it's written on, and doesn't communicate that to the client, is opening the door to be sued himself, because that client might then wanted to go to a different lawyer who maybe saw things differently and would make an effective will. So I think there's certain information that you must share with your client if you're going to say what I've just done isn't effective. And I think the approach of saying, you don't say to them, I think you're nuts, you better get a doctor. I think you want to say, hey, we want to make this bulletproof, so let's get a doctor so that nobody can make this claim, and then we'll get accomplished what we need to be accomplished. So, I mean, there's a good way of presenting bedside manner, so to speak, on these issues. But anything, that's why a letter to the client is better than a memo in the file. Mm-hmm. But a memo in the file is better than nothing. And
right.
So,
right.
Because in effect, aren't you saying that the witnesses were testifying or, falsifying, that if you didn't think the person was competent, that are the people who are now executing as witnesses, that they must be out to lunch if they're not agreeing with you?
well, they're not doing an interview, and they're not,
No, but I mean, I guess maybe you're calling into question their integrity.
No, they're just wrong.
Yeah.
I mean, it looks, a lot of people, I mean, the wife of Christ, you met her on the street, you think she was perfectly sane. You get in this one subject and wow, you go, wow, there's a sick person. So, you have your secretary witness the will. Well, what does she know about how sane this person is or isn't?
You could quickly end up in what I would call a pre-death will contest. where these things devolve into guardianship proceedings and a lot of accusations going back and forth.
Okay.
First is a question, then an observation about the healthcare power of attorney, which generally requires a finding of incapacity to trigger it. But I've wondered why we don't have more video proceedings relating to execution of these wills and trusts discussions with clients, because, boy, there can't be any better evidence than that, an actual video to re-show the court at the time something was signed or your preparation in doing it. I mean, I'm just wondering why we don't have that. What do you think the answer to that is?
Usually the videos are so bad, they destroy them. The two cases I've had where there were file memos saying there should be a video, everybody denied a video was taken. Both of the cases, I was 100% sure they took a video, and it came out so bad they didn't want to show it as evidence, so they destroyed it.
So bad in what way?
That it reflected unfavorably on the person's competence.
Okay.
And so the video disappeared.
So the reverse result of what you'd hope for.
Right.
I was at a seminar a while back with a couple doctors talking about the healthcare power of attorney, and they postured this presentation. They said, a person may be incapacitated to the point that a healthcare power of attorney would kick in. They can't understand the depth of the medical issues before them and what they've been told. They can't communicate back intelligibly what they want or need, but yet they know someone should do that. And thus they have sufficient capacity to execute a healthcare power of attorney, even though at that moment in time they would not be, capacitated, and the person at that point would be triggered. And what I'm getting at is this incapacity thing. It's never 100% zero, except rare instances. And I think as an attorney, we have to realize that people, especially as they get older, their windows of lucidity, as I call it, shift. They have good moments and bad moments. Very often I will say to a client, if we're going to meet in a facility, what's the best time of day to meet with mom? And they'll say, well, can't meet with her right after lunch, she'll be asleep, and we don't want to meet with her when she's hungry. And sometimes you have to prepare yourself to try and get in that window of lucidity. And another thing, I don't know how you feel about this, but I've always felt if the person I'm dealing with has a sense of humor, I have yet to meet a crazy person with a sense of humor, to be honest with you. My little indicia. I know they're all laughing at me.
You must not have seen the
You must
Joker.
not have seen the Joker, I say.
We have had a couple of claims involving children of a testator that the other family members didn't know about. How do you ask about that? Or assets that somebody didn't know about?
Have a good questionnaire for starters. And when we send that questionnaire out, we will indicate that we'll do the best job that we can, but our ability to do so will be limited if there isn't full disclosure of the assets.
Right.
Or of the general information about children and such.
Right, so you say, I'll build you a plan based on the information you give me. If there's other information and I don't have it, it can't be part of the plan. I can't know what I don't know, right?
Yeah, and that becomes especially relevant in funding of a revocable trust. It's not uncommon to get the questionnaire back with the first 2 pages filled out, and then the asset information is lacking from the questionnaire because the client believes that that's not relevant to what we're doing for them.
He's representing Donald Trump. It's none of your business what my assets are. How about you, Kevin?
I always do my own questionnaires. I don't send them to clients because I find they come back unreliably completed, and it takes me less than an hour to meet with them and get all the information I need. That is a standard question. All children, family relationships. I draw a family tree in my questionnaire, and they look more like bushes now than trees, and like shrubbery and all that.
Interesting.
Yeah, yes, they're very interesting. And I have had this come up where the mystery child has actually emerged in the meeting a couple times. One time in particular, they never came back and completed the plan. The other time, they agreed to exclude this kid that the one spouse didn't know about, and they did mirror image plans, so I felt good about it. But it's a question you have to ask, and they quite honestly may lie. So once in a while, I've had times where I've suspected that they were lying because there was an awkward gap in the conversation during the interview. But you only have the information you have in your questionnaire.
Kristine, do you have anything?
I think those are all good points. I don't know that I have anything to add.
And this applies to assets, I assume, as well as children.
Absolutely.
They always hide the cards on their assets. Almost all clients do. They never give you a full disclosure of their assets, even though they claim to. You know, clients are very funny about what they own. You know, and a lot of times there's kids involved and there's spouses, and they don't want to give complete asset disclosure. And I've just accepted it over the years. I don't know if it's good thing or bad thing, but it's too hard. It's like pulling teeth sometimes getting full asset info from people.
Well, one of the things that I've found that people forget about is
Tell 'em.
if they're the remainder beneficiaries on a life estate or something like that with their siblings, I've had people completely forget that they own this property because they think of it as mom's property or dad's property. It's not their property yet because their mom is still alive. And that can sometimes be an issue.
And stop me if we're going to hit this in a second, but with regards to privity and things like this, when you have and you're putting together an estate plan and you can see down the line, hey, this is going to cause some issues, the parents are doing things to the kids, but yet you know that because of how the Supreme Court has interpreted the laws and things like that, that they're going to ultimately could be privity to bringing you into a lawsuit. Do you ever suggest or, to say, hey, can we send these documents to these children, or that you have conversations with these children and document this stuff to sort of move that ball going? Because a lot of times what I find out is that they're doing this out of spite and they just don't want to deal with it, and they're creating something that ultimately is going to be my problem.
I'd say I actually deposed a guy in Milwaukee, a pretty well-known estate planning attorney, and he claimed that 95% of his estate plans, the family members did not know them. They were attorney-client privileged. I find in my practice, 95% of families know what's going on in their estate plan. They name other family members. They want copies of documents to be shared. So the attorney-client privilege, per se, breaks down very quickly. Most people are not that secretive about their estate plans. And I've usually found this attorney-client shield coming up intensely when somebody's getting ripped off or excluded or getting taken out, be it a marital agreement or a trust or something that knocks somebody out. Then there's all this secrecy that enshrouds the thing. But for most people, I think they want that communication level, and I think the family's probably better off if there's shared information, even if someone is getting favored. If there's shared information, there's less likely to be a misunderstanding down the road. And it's also kind of like this passive-aggressive thing where, the secret will reading after somebody dies, and all of a sudden you find out mom and dad didn't really like me. It's a pretty bad way to send that message to someone after you die, but people do it.
It seems to me that it's more important to share if there is an unequal or sort of a surprise distribution. Kristine, do you advise your clients to share their plans with their beneficiaries before they die?
I would say no, generally. Now, I can understand your reasoning why you would want to, but my personal viewpoint on it is that however you decide to distribute your assets is your own business. It's not your family's business. Your family shouldn't be expecting something from you because you say that you're naming them in your will, because chances are I might not be the last attorney that's going to represent them on doing their will. They might modify it a year later, completely different from the will that I prepared for them. And I think if they change their estate plan and then don't tell their kids about it, then it creates all kinds of other problems on top of the problems that you had before. I get a lot of clients that come in, the kids, after the parent has died, and they're all upset because what they thought was going to happen didn't happen. And I have to explain to them that it's their parents' choice to make changes in their estate plan, and they shouldn't have expected anything to begin with because their parents could have left it all to charity for all they knew. But they don't accept that very readily, and I think that expectation is reinforced. If you tell your kids something and then change your mind, you're just asking for a lawsuit after the parent dies.
How about you, Greg?
I take it on a case-by-case basis. I usually leave it to the discretion of the client. I think there are instances where more communication rather than less is better. I always encourage communication as to the types of documents that are being implemented and general information as to this is what a healthcare power of attorney is, this is why we've executed one, this is what a general durable power of attorney is, this is why we've executed one. And in fact, we'll encourage our clients, to the extent they're comfortable doing so, to have a family meeting to go over general estate planning principles from an educational standpoint. But we're very clear with the client that if there are areas that we need to stay away from, that those need to be identified in advance so that we can do that. I think I would tend to side, I think, a bit more with Kevin in that I've always believed that the client is the best person to communicate the import of the estate plan. They're here now. So better for you to communicate that to your loved ones and why you've done certain things, even if they decide to revise those provisions later, while you're here, while you're alive, instead of your family coming back and demanding of the lawyer, why did mom or dad do this?
Right. Right, because sometimes the explanation is, why I left more to your sister because she's less capable of taking care of herself, and I left less to you because you're fine. So it isn't meant to be hurtful. It's maybe meant to, I always thought your sister was dumber than you, so I feel like I have to help her more.
Or I left your sister's share in trust because I was concerned about creditor protection.
Exactly.
So things of that nature.
Okay, I want to follow up with Claude in terms of risks of disclosing and not disclosing.
We just have a comment from the web that
Okay.
I just wanted to share with you. This comment is as follows. I think sharing with your family that you have created an estate plan is fine, but it depends on the family whether the parents share the specifics of who gets what.
Absolutely.
So that was a contribution from,
Right.
from a web viewer.
So, Claude, so you've heard arguments for both sharing and not sharing. Let's talk about the risks of sharing and not sharing, or the claims that you've seen or the grievances that you've defended.
Well, I guess it goes back to who's your client, and never rely on informed consent. There is no such thing as informed consent, because it only comes up when something goes wrong. And unless you hit that right on the head and told everybody about it, it's probably not a valid informed consent. So I think anybody that relies on informed consent in representing multiple parties with potentially conflicting interests is taking a large risk. Plus, usually in providing informed consent, you're providing information that's adverse to one party or another, in just laying out why you need informed consent. So the first thing is I would make sure I represent whoever is making the will and not any of the beneficiaries, and make that clear. I think that the lawyer should not be the vehicle for conveying the news to the beneficiaries. If anybody does it, it should be the client. And if the client authorizes the lawyer to provide copies of the will to the beneficiaries, I would do it in writing. I would expressly state it's with the express consent of the client, and that the client will answer questions about what it means and not the lawyer. Again, it's keeping your skirts clean about who is your client, that you're not releasing confidential information without their consent, that you're following their instruction, and that you're not providing legal advice to the beneficiaries, because you don't want them to be able to say, well, I thought He was my lawyer. He sent me the will, and then I asked him questions, and he told me about it. And 90% of the judges will say, that's enough, unless you affirmatively said, you are not my client. That's enough for the client to reasonably believe they were your client regardless of what you might have thought. So I think it's really important to keep those things. And besides, the person that's making that allocation should be the one to explain why they're doing what, if they want to, explain what they're doing.
Right. Well, I can see some clients want to, some clients absolutely don't want to. Some lawyers would advise that, you should under these circumstances, or it's probably not a good idea, but we know clients don't always take the lawyer's advice.
Well, I think if you're, it's one thing to put in the document reasoning, if it's not hurtful reasoning, to explain it if they want to go that way and they don't want to reveal it until they're gone and nobody can talk to them about it. That's fine, but that's their decision. But we're only talking about situations where the client is telling you, I want you to disclose to the beneficiaries information. And that is their instruction. And I don't think you have to. You can tell them, well, you can disclose it. I'm not going to. You don't have to do that. But I think if you're going to do that, you have to do it in a way that makes it clear who your client is and that these people are not your clients.
A little practical tip, if you don't mind. Hell hath no fury like a beneficiary scorned. This destroys families. Practically, when the parents authorize or they want to share with their kids, even if the kids are treated equally, some will think they are, like Animal Farm, everyone's equal, but some should be more equal. And what I've recommended, and I find most people don't want to put that hurtful information, Claude, in the documents traditionally we use for reasons best known to us. But I have found most helpful for the parents to write a letter explaining chapter and verse. And the way that's helpful is that invariably in an estate, normally one of the children, usually the older one, has the dirty job of carrying out the game plan in which one of the other siblings is not going to get their fair share. And there's this suspicion many times that it's the fault of the older child. And to cover that child, I many times recommend that they have a letter ready to go so that they can explain chapter and verse if push comes to shove. But most clients don't like the idea of sharing with their kids because that just leads to a whole raft of issues. And I've seen it at least create major dissension, if not destroy, the relationships in the family. I think you have to tell the parents you can do it. Then also you have the idea that when you share all that stuff, whether it's you or another lawyer, 2, 3, 4, 5 years later you make changes, what do you have to do? Go back to all those people and tell them, well, you're no longer getting a half or a third. Boy, imagine what that does to the family.
Right, yeah, Kristine's point. Tom.
A couple of questions from web viewers. First one, where a testator wishes to disinherit an heir or heirs at law, does the panel have an opinion on the concept of urging the testator to leave a sum of money to the otherwise disinherited heirs with a proviso that if they contest the will, the bequest is forfeited? Obviously, the sum of money should be large enough to make it painful if there is a contest and the heir loses.
So that's called an inter aram clause.
Right.
I think they're kind of a dumb idea. I mean, they're questionable whether they're enforceable. In Wisconsin, the statutes, if you read it, it's sort of funky wording. Most courts aren't really willing to enforce them. I'm trying to think if I've ever seen one enforced in 29 years. It is a good idea to provide something for the person that you're diminishing what they'd get as an heir at law, I think. That question, I think, is clear.
Yeah, you should. It just...
More than 5 cents.
More than 5 cents.
Right, common sense. I mean, to say to somebody, you give up whatever right you had in probate court for a payment. I mean, you shouldn't be able to...
They put them in there anyway because they want to scare the beneficiaries. So the person dies, they come into the lawyer's office, and the lawyer says, hey, read this. It says if you contest this, you're getting nothing. And so that's why they still put them in, to scare the people after they're dead. Is it a good idea? I don't know. I've never used one myself. I don't think it's a good idea.
Okay. One more from the web.
Sure.
With regard to Roman numeral 3, page 3, in the written materials, disclosure of information or copies of a will to family, personal rep, after death of testator. How can deceased client consent? Can you ask the client prior to death when contemplating, or rather when completing the estate planning docs, to whom, if anyone, can you provide a copy of the will after death?
Well, first off, there's a state statute that requires the custodian of the original will to file the will within 30 days of the decedent's passing. And so it would be relatively easy for relative to then get a copy of that at the local probate court. I suppose you could have instructions on who's to receive copies. If the will is being probated, then interested persons are entitled to a copy, and you go through the notice proceedings, or you were able to obtain waivers from interested persons to open the estate. If it's a situation in which you have a revocable trust and a pour-over will, and there will not be any probate, then you run into the situation where we typically will go ahead and file the original will once it's provided, or encourage the custodian to file the original will. And then if there's some type of controversy as to who should be receiving a copy, you can point them to the probate registrar.
Well, and it's not confidential unless it's intended to be confidential, and a will is not intended to be confidential after the death. So I don't think confidentiality would even apply in that situation where it's obvious that the testator intended that will be disclosed on the testator's death. It's like getting authority from a client to settle a case. It's not confidential. You know, they're telling you, yeah, okay, I'll take this much. They don't have to say, oh, and you can tell the other side. It is intended not to be a confidential communication. It's one intended to be communicated at some point.
You know, one of the benefits we sell for a trust is the privacy thing, but everybody should know that the attorney-client privilege is broken on death in Wisconsin. The statute is very clear. There's like 3 or 4 exceptions in the statutory terms. If your claimant's through the same deceased client, there's no attorney-client privilege. So that means anybody who could potentially contest that will has a right to see not just the will and trust, but all the estate planning files. So if you think your file is sacred or can't be seen, and a lot of litigators make this mistake. I know I get in cases, and I'll have really good seasoned litigators come into a case, and they'll be hiding the files and all this stuff, and you just can't get away with it. In this area of the law, the documents are usually attested to by the attorney. That's another exception to the attorney-client privilege. The claimants through the deceased client, the way that's written is so broad that everybody has access to everything when the person dies. So if you think you're going to hide it from somebody, if they want to know, they're going to find out. They may have to get a court order to do it, but they'll be able to get at your estate planning file.
And that's whether they're listed as a beneficiary or
If they have
not.
any, yeah, so if they have any interest, so if they're in an area of law and they got written out of the trust, they're going to be able to get access to that info.
Comments or questions before we move on? Yes.
Kevin, following up on that, so to protect yourself, if a client leaves a letter for you to share with the family, obviously you'd share that. I'm thinking of an unequal distribution. But at what point do you protect yourself and wait for the claim to be filed before you give up all your notes on their reasoning? Like, how far down the road do you recommend going to kind of explain to the beneficiaries the reasoning that the client had, knowing that if they filed a claim, you'd open up all your notes?
It's got to be a judgment call. I mean, I think I had one where recently where the woman died, and I just sent it to both sides who were in litigation, a copy of all the documents she signed. I did not send my estate planning questionnaire. No one ever asked for it. I was thinking about that, though. What happens when they see the questionnaire? And it was a lot of handwritten notes for me. That's basically what it was. And they were extensive. I mean, they were pages of notes and different meetings. I had met with her 3 times. with her personally, and then a couple times when kids were present. And nobody ever contested the documents, but that was my concern, is that somebody will ask for the notes, and then what if there's a mistake in there, or what, I mean, these are the things we all live through, but I think if anybody pushed it, they would get a copy. So.
Okay, the first estate plan I had made for myself was when I was pregnant with my second child. So I had one 14-year-old daughter and one imminent daughter. The estate planner that was working with me said, these two children have very different needs, and these needs will change with time. And the estate plan I do for you now, in 5 years, is probably not going to be what you intend anymore, and might not be what these kids need. And it is very clear in my mind that she said, basically, an estate plan lasts about 5 years, and you really need to take it out and look at it. And I have done that 4 times. It's really true. It really changes specific bequests in terms of what I want to go where. Is that advice, Kristine, that you give clients?
Yeah, absolutely. They're the needs of them, the needs of themselves, the needs of their children change. I just had one recently where the client decided they wanted to change their healthcare power of attorney and regular power of attorney, and used a friend, and then there was a falling out with that friend. So now there's a need to activate some of that stuff, and now this friend that they didn't no longer have this relationship is going to be involved in their personal life. I mean, that's not a good situation. So reviewing that often is important.
Yeah, I would not want to be unplugged by my frenemy. How about you, Kevin? Do you tell your clients to look at it every some period of time?
I think we do that. I would say most people don't. They take a lot of time. It seems like drafting estate plans, people can go anywhere from the minimum time I think people take is about a month unless they have a serious health problem. And I've had people go on for years where they can't make a decision. But as far as making changes, usually it's the executor trustee role that changes. That's the most common change you see. They'll decide, okay, this person's really financially irresponsible. I didn't really realize that when I named them 15 years ago, so I'm getting rid of them. Or they have a family rift, and for that reason they make a change. There could be a lot of reasons. Divorce is a common thing. Something happening with the kid where they didn't like what happened, they might make a change. But most people kind of leave it alone, don't make a lot of changes.
How about you, Greg?
I encourage people to review their documents. I also, though, think you can draft in a way that anticipates future changes. We'll typically draft our documents. It's a bit informal, but we won't refer to these names of the specific children. We'll just have general language that says, essentially, when I pass, establish a trust for each of my then living children, and here's how the trust will be administered. And so that protects the client from there being some change in circumstance. A friend will come up to me at church and say, oh, well, we just had another child, we need to arrange for a time to see you. And I say, rest assured, you don't need to worry about that unless there's something else that's driving you to come see me to revise the plan. And guardians is another one.
Right.
My wife and I have had to change our guardians now 3 or 4 times. So that's one that people need to be really conscious of as well.
Well, and that was part of my situation, right? Because my plan had a guardian for the baby and a trust. So as time goes, there's no more need for a guardian, and one day she won't need her money held in trust.
Kathy, I have a question.
Yes.
The tax laws have changed dramatically. And if you've done estate planning that involved a lot of tax planning, that has now become, at least under current law, unnecessary, what role, if any, or obligation, if any, does the estate planner have to contact clients and suggest they come in and review their estate plan? In other words, can your plan be too complex because you've tried to do tax planning?
Yes, and I'll give a concrete example. Until EGTRA in 2001, we were drafting a lot of plans in which there was the required funding of a credit shelter trust on first spouse's death. When the law was enacted in 2001, I think most of us started using disclaimer bypass opportunities to fund the credit shelter trust, but I still will run into older wills, older trusts in which on first spouse's passing, there is a requirement that the credit shelter trust be funded. And now that we're nearly $5.5 million federal estate tax exclusion per person, portability between spouses, they have a net worth of maybe $1.5 million. It's overly complicated. What I've struggled with is what duty do I have to reach out to these people? Do I have to go through all of our files, our hundreds of estate planning files, identify which clients had the forced funding of a credit shelter trust, and then proactively contact all of them? I think there are some ways using disclaimers that you can post-mortem make that situation a lot less complicated, but it's probably going to be more costly than it would be for them to come in and simply revise their estate planning documents. So that's an area that I struggle with. I guess I'm interested in your perspective on that.
Yeah, I actually have not amended them. There's still several of them out there, and there's things you can do after they die. One example is usually it's a surviving spouse, almost always is the trustee. So the surviving, first of all, there's no real cause of action against the surviving spouse because usually it's she, because women outlive men, she is going to be dead by the time the kids figure out that trust wasn't funded. But if you want to do it right, there's a lot of things you can do. One of them is just have surviving spouse give a promissory note to that credit shelter trust, and then the trust really kind of holds nothing, sort of holds air. Mm-hmm. So there are some ways around it. And the residual beneficiaries are almost always the same. So the bottom line is the same people are getting the money, whichever trust would have been funded. So there's really no damages. I don't know if that makes sense to everybody, but.
We do see a fair number of estate planning claims, though, for unintended tax consequences. So that is an area where,
But here there's unintended no tax.
Right. We don't see those.
Would just a letter to all estate planning clients saying that the tax laws have changed and that they should possibly review that might be enough to protect you if somebody later makes a claim, oh, you should have told me about this or given me a heads up.
Are they currently a client, though?
No.
And is that a
It's
solicitation?
everybody that you've done an estate plan for.
Right, but then is that a solicitation?
It's an offer.
Well, if you file it with and put, this is an advertisement on the bottom, you can file it and then it wouldn't be. But I would think that the definition of who is a client, I find when you're dealing with former clients or clients that haven't done anything recently, varies greatly from firm to firm and lawyer to lawyer. And
court to court.
Yeah. So I guess if you don't say, come and see me, you say you should maybe have it reviewed without saying by whom, that might not be considered solicitation.
I would worry less about the solicitation criticism than I would worry about a claim coming down the road. And this is not estate planning, but we have a telephone call.
At least I'm not in court.
My cell phone quacks like a duck. That would have been worse.
I think my speech should be over now. I think that was the alarm.
What we have is a mortgage foreclosure, and the lawyer representing the bank on obtaining the foreclosure judgment went to enforce the judgment against somebody who it turns out the lawyer had previously represented. And in the malpractice claim alleging conflict of interest and collusion and fraud and conspiracy, also alleged breach of fiduciary duty. And the court had the most trouble with the breach of fiduciary duty on what duty remains obligating this lawyer to that former client. So at least if you were in the Western District of Wisconsin, your much stronger argument is that you have an ongoing duty to your former clients to advise them that that there may be unintended consequences to an estate plan that you did for them rather than a problem with soliciting new business.
Sure, and I think estate planning is kind of unique in that aspect, in that we take on sometimes a role that's more analogous to a financial advisor, and that there needs to be some ongoing contact with the client, and it's not as discernible as to when the representation begins and ends.
Sure.
So it's another challenge, I think.
Sure. Well, and in Wisconsin, it's the disenfranchised beneficiaries that can also go after you for a claim, people who weren't even your client. In Texas, I don't know if it's changed, but the rule used to be, the common law rule used to be that only your client could make a claim against you. So you draft an estate plan. It's not what they want. You don't know that till they're dead. So how they come after you for a claim, I don't know. But malpractice insurance should cost less in Texas for estate planners. Nobody can sue.
But if you send out a letter, dear client, to somebody, remember that you then can't take a case against them. You know, because
And
they have a
represent a
document.
beneficiary.
They have a document now that said you considered them your firm's client. So the probate group and the other lawyers in the firm sometimes don't see eye to eye on who is a client because it creates conflicts.
It's a quagmire. Do you have an observation or a question?
Yeah, I was going to say, are there other areas of law, let's say more so specifically, if there's changes in like business law and you've worked with a client, I guess there are parallels to be drawn from other areas of law. I mean, the laws change in all kinds of areas, not just estate planning. How are those changes communicated in other areas? Tax laws change, with respect to businesses. That's not specifically estate, active and ongoing conducting of a business. As a lawyer, if you've worked with them, and now maybe their business succession plan needs to, be changed and reviewed.
Right. I think the difference is that in an estate plan, you have a document that you've helped the client create that will, at a point in the future, carry out the client's intentions. And if you learn some information while the client still can have their intentions honored after their death and there's time to fix that, offering to help them with it makes sense. If you have a different representation where you helped a business client and they bought something or sold something and then it's done and you part on good terms and then the law changes, their intent at the time was carried out by you. The thing with an estate plan is you're talking about current intent for future action.
See, and I'm thinking maybe of a case where you've drawn up a business succession plan and something changes in the law and it hasn't been carried out yet. Don't you have kind of a parallel situation where you're thinking, well, maybe they should review this because maybe it's not the same financial consequence. Maybe they should be doing this a different way now.
Right.
And how do they handle it in that area?
That's
Well, first of all, there's a difference between duty and contacting somebody to say you might want to look at something. And the question is, are you soliciting work and so forth? So if I have a corporate client that I've represented for 10 years but haven't done anything for a year, I suspect they believe, and I believe, they are a client. And if I sent them a letter saying, hey, you should consider looking at your succession plan because yada, yada, I don't think anybody would find a problem with that. Now, if I only did one transaction for them and 4 years later I'm sending a letter, that might be a different situation. But with respect to duty, if you were asked to do this succession plan and you did it and you completed it, I think that anything that's done to change that would be a new engagement, and that you would not have an obligation, affirmative obligation to track them down, because literally you would have to review all your files every month to see if anything's changed. So that isn't your responsibility. So I think if you do it proactive, that's okay. I don't think that creates an attorney obligation either, because you're simply asking, maybe you should take a look at this. And if they don't contact you, I don't think that you're responsible for changing anything. And even if they did contact you, The example I gave of changing the will to cut somebody out, there might be a conflict because maybe you're representing these two principals in other matters, in which case you have a right to say, no, I'm sorry, I can't help you, you need to go elsewhere.
Yeah, I think they do. Sometimes the clients do become adverse. Like I've done estate plans for 2 different business partners, and then they blew up and got in a fight. And you know, I'd rather not send them that letter saying revise your estate plan, because I don't want to create I don't want to create the understanding with them that I'm constantly monitoring what they're doing. I think if they may have a life change or whatever, they should come to you.
It almost seems like there's maybe is the panel thinking maybe that the standard and the obligation you have to the client may be a little bit stronger when you were dealing with an individual with their own personal situation than in more of a business setting?
Well, I was thinking about this issue from my family law context. Like, let's say there was a change in the child support guidelines and the child support was going to be modified in the future based on different criteria. I don't really want to go back into all of my files and notify people that I haven't talked to in quite a while and say that they need to go in and change their child support obligations or review that. Maybe a newsletter, or maybe me putting out on my firm's Facebook page, hey, you should be aware of this change in the law, and have them contact me, I think is a better approach to that.
It seems though that the panels may be saying you feel more obligated to contact someone for an estate planning change versus no, or maybe you're not saying that. That's kind of the thought that I'm getting is
Well,
that.
Koch's point about it being a prospective, you're advising them and creating an estate plan for something that's going to have prospectively, I think is a big distinction between her example and my example. So I was kind of running that through my head too. But I'm not sure that, again, it creates that obligation going forward, and I think that's a dangerous place to go down, because what about the people that you miss?
Right, and I don't think, my understanding of when my estate planning lawyer advised me to look at my own estate plan every 5 years to see if the facts still fit, she put the obligation on me, and I think that's appropriate. And I think Claude's point was, you don't have an obligation. There may be, it may be a circumstance where you choose to do it. You may choose to do it in a, just tell all my clients, the newsletter, Facebook, webpage, changes in estate planning law, that kind of a thing. So there's a difference, I think, between wanting to do something, having to do something, wanting not to do something, and, Greg, the famous answer, it depends. Right. The one-size-fits-all answer.
A web question. How long should you, or let me put it this way. It says, can you destroy a client's estate planning file after 7 years?
I would say no.
If all the beneficiaries are dead.
Okay.
Not until they die. I keep them permanently, and I scan them all after I draft them now. For the past maybe 8-10 years, I've been scanning them. I don't think you can get rid of them. I'm not sure what I'm going to do when I retire. I know that came up earlier today. I know of other attorneys who've deposited them with the probate court. There is a $20 filing fee, and that may be the exit strategy for some. I don't know, or to get it back to the family. And the problem with all of this, you're going to write a letter to your client. You did their estate plan 10 years ago. You don't even know where they are. My clients die a lot of times. I don't know that they died. Because with living trust, we designed this whole thing to be a vehicle to stay out of the court system. And so you create a probate avoidance mechanism. You kept them out of court. If everything works smoothly, you never hear from them. Or there's 1 or 2 phone calls after somebody dies. Hey, how do I do this? Do I set up a bank account? But then they take care of it. From that point forward, you don't hear much of anything. So it's not that unusual to lose touch with your client after the plans are done.
From the carrier's perspective, we do like you to maintain your file in some form. Just filing the will, it's not the will that's going to defend you. It's going to be your notes or correspondence to the client that the client never saw, says they never received, but your file has it. So from a defense perspective, we like you to have it. From a practical perspective, that doesn't always work.
Our policy is not to retain the original will. The client
Right.
has the original will.
Right.
We may have the revocable trust executed in triplicate so that we can keep an original. We have the state laws, statutes that say that copies of powers of attorney are considered originals. So likewise, we scan the documents into our system, but I would be very nervous about destroying estate planning files after 7 years.
Happy to hear that.
Katya, another comment from a web viewer. Some confusion as to an answer on disclosure of estate planning documents to personal rep, other heir after death of testator. Did Kevin say that because attorney-client privilege expires at death, anyone, any heir at law, can get any estate plan information from the attorney, and that the attorney has to release information upon request of beneficiary? But heirs are not your clients either. Why do you have to disclose any information to them?
If it gets pushed to a court order, so somebody makes a claim, and an heir at law would have a claim because if the document's invalidated, then they become an heir at law. So they are automatically a claimant if they make a claim, and at that point, they can, when push comes to shove, they can get a court order getting your whole file. That's my interpretation of the statute. The way I read the thing, the way I've ever seen any judge interpret that, is that the privilege does not apply to disputes between claimants involving the same the decedent, and then the documents themselves are not privileged because they were attested to by the lawyer. They usually are notarized, and so these are the documents are not privileged. So,
What if your personal representative tells you, I don't want you to provide a copy to?
then you don't until you get a court order.
I know that in the new UTC that it says that certain people have to be provided with copies of the revocable living trusts and things like that. But aside from the probate or aside from the will side of things, with just dealing with revocable living trust, what if you have a sort of a privacy type of portion in the trust that says, I don't want this thing distributed out to all of the different beneficiaries and things like that. That the reason we're doing the revocable trust is because it's private, because we don't want this. What's your argument then as far as when these beneficiaries come back and say, hey, I want a copy?
Comes up all the time. Lawyers make the mistake. They say, I'm only going to give you the paragraph 2B that says what you're getting and nothing else. You got to give them the whole document. I mean, bottom line is, how can you really figure out what you're entitled to unless you read the whole document? And so I don't see any way you can get away with that. I think if it ever comes to a hearing and a judge looks at it, they're going to give you the whole document. There is no privilege attached to it. There's public policy reasons for not allowing that kind of behavior to go on because it allows, I mean, I had a case years ago where this attorney made post-death amendments to a trust. And what every beneficiary got under this thing was stapled on. Schedule A was for Johnny, Schedule B was for Jane, Schedule C, and it was all just a big sham. And he took the position after they died, the ones he liked better, he could give more money to, which is totally contrary to law. The other thing is, as a fiduciary, if you look at the general common law, you have a duty of full disclosure. That's one of your many duties, full disclosure, impartiality. So you can throw away everything they teach you about litigation when you get into the fiduciary setting because your obligations are substantially different. In litigation, we always try to hide everything. But when you're a fiduciary, full disclosure of all information, regardless of whether it's helpful or hurtful to you. Impartiality, you can't treat one beneficiary better than the other because you like them better. So those kinds of rules in fiduciary law upset the general understandings that people have in litigation that they don't have to share things.
And here the class of claimants could be much larger than the class of beneficiaries, so you have that tension as well.
Right.
Well, which leads us to a really interesting topic, which is trust protectors. Who wants to start talking? First of all, what's a trust protector? Greg?
A trust protector is someone or some entity serving a specific role in the context typically of a trust agreement, in that they're allowed to do certain things that might otherwise be considered to be beyond the role of a typical fiduciary. So you could have a trust protector say a provision that says if the tax law is changed to the beneficiary's detriment, trust protector is authorized to modify the trust to the extent that such modification will eliminate that tax liability. So very specific authorization of very specific things that entity or individual can do to try and effectuate the intent of the grantor.
Okay, and I wrote down what Kevin said about post-death amendments to a trust.
Yeah.
Is that not what the trust protector
I read the
does?
statute. I don't know who wrote this trust protector thing. It's bizarre. I think, we have enough problems in the trust world and litigation and families, and to throw this thing in here, I think is overly complicates what's already a really complicated set of relationships. You have the family relationship, then you have this fiduciary relationship. Now you're interloping another person involved. Maybe it's a CPA or something. So now my CPA can come in and decide who the beneficiaries are after I'm dead, or
drafting attorney.
or drafting attorney, and all these. And then these people aren't really compensated. So I don't know why you would ever be willing to be a trust protector. I suppose you could write something into the agreement that you're paying the person, but they're assuming all kinds of fiduciary obligations. I don't know why this was put in here. I just can't figure it out. I've never used it. I'm never going to use it.
Yeah, I cannot emphasize how much I agree with you. It seems whacked to me to have somebody with the authority to change something after somebody dies. I don't know how that isn't a complete can of worms. But I guess the answer is you make it very specific as to what kinds of things they can do, but.
I wouldn't advocate putting it in the boilerplate language, but I think there may be specific cases where it's advisable to have someone in that role as long as their responsibilities are very specifically delineated.
And should it be the same lawyer that drafted the trust?
Absolutely not. So.
Write that down. Absolutely not.
One thing you can do, like charities is one thing where people say, hey, I'll set up a foundation, or I'll let them determine what charities they want, that my personal representative decides something like that, or my trustee. That kind of makes sense to me, that sort of a delegation, but most of these other things I think don't make sense.
Claude, have you seen claims or grievances arising out of a lawyer's work as a trust protector?
I've never heard of a trust protector, so the answer is no.
You will. You will. It's coming.
I've heard of a trust protector with respect to being used to terminate an irrevocable life insurance trust. And that was long before the new trust laws came out. It was written in the document, and it actually was invoked and the trust terminated.
Okay. Anybody else have experience being one, writing an estate plan with one, wishing they hadn't written one? Anybody out there on the web? As a carrier, I mean, this is really nerve-wracking. Except we'll always have work, which is, we like that.
There, in the new Uniform Trust Code that was recently implemented, there's additional guidance on what that role consists of. So there's recognition on the part of the real property probate and trust section of the Wisconsin Bar that there needs to be some definition as to what that role consists of.
Right, and common law will develop, so we'll get some clarification as we go down the road. All right.
Web
Yes.
question,
Yep.
back to the issue of file retention. Does returning the file to your client relieve you of retaining anything?
I think vis-a-vis the client, it does. Whether you need to retain a copy for your own protection is maybe a different matter. And typically, when lawyers are asked to return the file to the client, it's not a good sign. And so we often recommend that you keep a copy, or you send them a copy and keep the original, depending on ownership issues. But again, I think you have to give the client sufficient information so they can make a reasonable decision on whether they should get their file back or have it destroyed. So you can't just willy-nilly follow their instructions.
I would argue best practice is to make a copy, to retain a copy. That's what we would do.
Okay.
It's so easy to make copies and have it scanned into your file nowadays. It seems silly not to. And I think that's probably going to develop in be part of these malpractice cases. Well, why didn't you do that?
Because you can.
Yeah, well, the more of you that do it, then that becomes the standard of
We
care.
used to have Benny the burner, that we would take the files down and would burn their files. We never burned a probate file, to my knowledge. I think we still have probate files and estate planning files going back to the beginning of the firm. And I think at 100 years or something, you probably can destroy those with fairly high confidence. It's not going to be a problem. But yes, because you can, but then you have to preserve your electronic copies, and having it in your office where it could be burned down is not such a good idea. So you need to have an off-site place to have your electronic data stored to.
Or a backup that's offsite, or up in the cloud,
And
which
I
is
wouldn't
offsite.
put it on the cloud
You wouldn't.
because of confidentiality issues.
I have one topic. Oh, Tom, you have
A quick comment from a web viewer back to the trust protector issue. This viewer writes, per the panel's question, I have been involved in 2 estate litigation cases with 2 separate law firms in which the drafting attorneys made themselves the trust protectors. So, for what that's worth.
We think it's a bad idea.
Yeah.
So they probably wanted to maintain an active role in determining who gets what and how things were administered, the law firm.
Somebody who wants to be really helpful. I mean, that's what we find. A lot of times claims will arise because a lawyer wants to be really helpful, thinks they are in the best position to know what their client's intent was. This doesn't quite do it. So if I'm the trust protector, I can finish it up. I can finish what I started. Well, yes, I think it is a mistake. I agree with you, but it's usually motivated by very good intentions.
But if you get a fee, that makes it dicey. If you get a fee, because you've drafted the document that you get a fee. So if you want to do it freebies.
Just take a nickel, 5 cents, right, Greg? Any other topics that you want to get to? I'm going to ask the panelists for closing thoughts. I have one other topic, because I want to make sure you get all your credits. So we're going to go up until shortly before noon. But I do want to give you a chance if there's something you want us to talk about. Yes.
This goes to the testamentary capacity question. There's some commentary suggesting that if an attorney presides over a will signing ceremony, they're making an implied representation to maybe the court that ultimately receives the will or to others that the testator's competent. That seems to run afoul of the idea that we're not the final arbiter of that, but does the panel have any thoughts on whether just the act of, in a close call case, having somebody go ahead and sign the will in your office increases your risk?
Kristine, you want to start with that?
I'd rather pass.
I would say definitely yes. It increases your risk of being a witness and maybe a defendant in a lawsuit. And if it's a close case, I mean, I've had a couple of these knockouts recently where I'm like, go to the bank and get this thing notarized. I'm not going to be a witness. I mean, I'll be a witness to the drafting of it, but I don't want to be a witness to the execution of it. Go get a third party to witness the thing. Just because I kind of felt, I don't like estate plans that knock people out anyway. I mean, it's like writing marital agreements are the same thing. You're setting yourself up with an enemy, okay? That person who's, there's a winner and a loser in that transaction, and the loser is going to be looking for responsible parties later. So when you draft a marital agreement that's really oppressive to one of the parties, they're going to come back and probably try to blame the lawyer because they're going to try to blame everybody. And the same thing with an estate plan that really rips off a spouse or rips off a kid or whatever. Somebody's going to ultimately have to explain what happened at the end and then possibly be said to be responsible by someone else.
We call that being the lightning rod of somebody's discontent.
Right.
So you're on the witness stand and you're asked, well, were you familiar at the time this will was executed with the requirements of competency? Well, yes, I was. Did you understand at that time that if the testator was not competent, that the will would be invalid or the document would be invalid? Well, yes, I did. and you went ahead and proceeded with the execution of the will, yes. And when the testator died, you filed it with the court, yes. So are you telling me you didn't know whether or not that person was competent when you had them execute this will with the intent of it being filed as a public document? So I look at it as something that, regardless of your legal technical argument, is pretty tough when you're asked those questions, because you're basically saying, like this guy who wrote a letter saying, no, this will isn't worth anything, I had this guy sign because he's nuts. I mean, I just find that incredibly incriminating on drafting a will that you know or should know or have significant doubts as to its legitimacy. And then if you're the person that has it filed to the court or you're handling the estate, it's even compounded.
All right, Kristine, I have a question for you. Do you consider a client's liabilities as well as their assets when you're drafting an estate plan? And the reason I ask is, say mom has 2 kids and she wants to give the son cash, $100,000, and wants to give the daughter the $100,000 house, and say there's a mortgage on the house, and you're thinking daughter can't afford the mortgage payments. So she's going to get an asset that actually winds up not being an asset for her. What do you do about that?
I think it definitely is something that you want to talk about. You also want to talk about their other debts that might be have to be satisfied in the estate, and how are they going to be satisfied. So when you put together, I think they need to know that in a probate proceeding, for example, the claimants are going to be filing claims for their liabilities, and that may have to be figured out as to how those claims are going to be satisfied. Sure. So is there going to be any liquid assets to be able to do that, or are you going to have to sell the house or somehow encumber the house in order to be able to pay off those claims?
Does that raise the issue of who is your client?
To a certain extent, but also I think you need to remind the client that $100,000 in cash is not equal to a $100,000 house that's encumbered.
Or a $200,000 house that's encumbered with a $100,000 mortgage,
Right.
because mom could look at that and go, okay, that's fair. He gets cash and she gets $100,000 in equity.
Right.
Right?
Right, and there are administrative costs. So even if you then come back and say, well, daughter could sell the house and get $100,000 worth of equity, not exactly, because you have the transactional costs associated with it.
Right.
I think you definitely have to have that conversation with them.
Okay. Anybody see that differently? Kevin?
Yeah, these are real problems, and they end in partition actions and things like that, and you'll get the vacation property where one family member can afford to keep this thing afloat, and then the other one, hey, I want my money, I want to cut and run, I'm done, I don't want to vacation with you anymore.
Yep.
But you see this in farms, you see this in a lot of different things, or a house where they'll pick a beneficiary and say, you get to live there for the rest of your life, and you're supposed to pay all these bills, and then they don't pay the bills, and it's complicated. Yeah, it's really a mess.
Yeah, we see those. Those are our claim files.
Well, and I think part of it is explaining to the client, these are the consequences of what your decisions are. So that partition, I've seen a partition recently where I think when the parties jointly bought this property, they never thought, I think they thought eventually it would get sold and they'd each get their 1/3 of the money. Well, now there's a falling out, and now it's in the judge's hands about what the judge is going to do with that, and the judge's opinion is different than the attorney's opinions. And I don't think anybody is going to be satisfied with the outcome of that, but those risks have to be explained to the parties when they're about ready to embark on something like that.
Agreed. Tom?
A couple of questions from the web. Back to file storage. What if the client asks you for their file back and asks you to destroy any information that you have? Do you have to destroy your files or notes?
Ooh, let's start with Claude on that.
I have never, ever seen that in 43 years, a demand that you destroy the file. I think that the rules are pretty clear that a lawyer can protect themselves against potential claims, including providing, it's an exception to the privilege rule. I don't think you can use that, if they sued you, you could use that confidential material in your own defense. So I don't think you would have any obligation to destroy your copy of the file. You would have to return to them originals of documents that they own. But there is no such thing as the best evidence rule. So a copy is just as good, if that can be authenticated, as the original, at least unless there's a statute that requires an original. If in a typical case, a copy is just as good as an original document to prove a point, as long as you can authenticate it. So I would say no, you do not have to destroy. Of course, you can't put it on the web, your web page either, but and you can only use it for limited purposes.
Anybody else see this differently? All right, do you have another question?
Yes, second question from the web. Did you suggest that a testator who wants to exclude an heir leave that heir something anyway, or were you suggesting that be done in situations when the will says no bequest to the beneficiary if the beneficiary contests the will?
I think this is a Kevin question.
Yeah, I think you should do something for that person, because it's particularly if there's a decent amount of money involved, because then you're at least giving some recognition to the person, and but it's obviously up to your client. And a lot of clients come in and they want to give them nothing. I just think it's bad form for the decedent, but it's their money.
And if I understood what you said earlier, for some of those clients, then you say, I can't help you, you need to go to a different lawyer. And for some of those clients, you will continue to do as instructed in spite of them not taking your advice.
Yeah, my thing is, if they give me good reasons, then I'll do it. Otherwise, I'll just tell them to go somewhere else. And I don't feel that bad about it, because you don't make that much money on doing estate plans anyway. And so if you can already see warning signs when they're in your office drafting it, maybe it's time to get rid of them right away.
That's generally our risk management advice too. There are just clients you need to part ways with, and there are points in time where you can and points in time where you can't. But if there's a time when you can, life is short. It shouldn't be this hard.
Well, I think you need to also point out that it's creating a potential problem for the favored beneficiaries, because it's going to guarantee a fight.
Yeah, they don't. Yeah, they got.
And then the lawyers end up with the estate rather than the beneficiaries.
Yeah, Charles Dickens wrote a book about that. It's called Bleak House. All right. Any closing thoughts, Claude?
No, I think I've beat it to death.
Write it down.
When problems arise, contact your insurer, get legal representation before you open your mouth and start dealing with the problem and talking to the client, and that will protect you and the client.
Kristine.
I feel pretty strongly in my family litigation practice that people that have diminished capacity in some way need representation, and I don't shy away from cases where they might be bipolar or have some other mental illnesses that make it more difficult to represent them. But I think you have to be smart about it, and it's really important to read not only Rule 1.14 in the Supreme Court rules, but also the comments by the ABA, and I believe those are included in your materials. But the comments go into quite a bit more detail about what your responsibilities should be to your client, and they don't answer all the questions by any means, and I'm sure we're going to see a lot more issues related to that. But one of the first things that the people from OLR will do is call you up and go through the list of the things that you should have done if you expected that your client had diminished capacity, and have those answers ready, because as long as you go through the steps and evaluate about whether they can assist you in representation, whether their wishes are reasonable and protect themselves, you're probably going to be okay. But if not, then you may have to get the appointment of a guardian ad litem or something like that to help you. Now, I know that doesn't help in the estate planning context, but it might help in some of your litigation contexts.
Thank you. Kevin?
No, I'm just thinking of a couple scenes from Caddyshack that night. The one where he says, you know, the world needs ditch diggers too, and the caddy asks for a scholarship. I don't know, some of these people and their problems, you know, you don't have to take them on 100%.
How about you, Greg? What movie is running through your head?
The same one, no? No, that's a great reminder, and I guess this just reminds me not to get so busy in my day-to-day practice that I don't keep these issues at the fore and remember the potential for problems down the road.
It is important to step back and take a broader view of what you're doing and why you're doing it. The real problem clients actually can keep you from doing the work that you want to do for the clients that aren't a problem. So it's a disservice to your good clients if you continue to beat your head up against that. Well,
Could I make one more comment?
you sure can.
We all know when we have a bad client. And why don't we cut our losses and terminate that relationship right away rather than hanging in there until there's a claim brought in? You know, there's nothing wrong with firing a client if you do it right and say, you know, we're just not getting along. You need to get other counsel. I will cooperate in the transfer. It's better to do it early than late. And
there are other lawyers who will take those problem clients and do just fine.
many other ways.
Yes. Somebody married my ex-husband. And we are done. Thank you very much.